8 Supreme Court justices just agreed on something about your gun rights, and that almost never happens. If you own a firearm, have a concealed carry permit, or simply believe in the Second Amendment, the next 10 minutes could be the most important thing you watch all year. Quick question before we continue. Are you subscribed yet? Because what I'm about to walk you through is the kind of legal update that changes how you carry, where you carry, and in some cases, whether you legally can carry at all. Most gun owners are completely in the dark about this. Hit that subscribe button right now so you never get caught off guard again. Seriously, do it before you forget. Okay, let's get into it. So, here is what just happened. In June 2024, the United States Supreme Court handed down a ruling in a case called United States versus Rahim. And this was not a close split. 8 justices voted one way. Only one voted the other way. That is as close to unanimous as the Supreme Court gets. Chief Justice John Roberts wrote the opinion himself, which tells you right away that the court wanted to send a clear, unified message to the entire country. And that message has real consequences for you as a gun owner. Here is the story behind the case. A man named Zaki Rahim was under a civil domestic violence restraining order. Now, a restraining order like that is not a criminal conviction. It is a civil court order that says a judge found credible evidence you are a threat to someone's physical safety. Federal law, specifically a section called 18 U.S.C. 922G8, says that if you are under one of those orders, you cannot possess a firearm. Rahim challenged that law. He argued it violated the Second Amendment. The Fifth Circuit Court of Appeals, which is considered one of the more conservative federal courts in the country, actually agreed with him. They struck the law down. So, the case went all the way up to the Supreme Court. Now, here is where it gets interesting. The Supreme Court reversed the Fifth Circuit 81. They said, yes, the government can temporarily disarm someone who a court has found poses a credible threat to another person's physical safety. The lone dissent came from Justice Clarence Thomas, who has been the court's strongest voice for expanding gun rights in recent years. But here is the part that most people are completely missing. This case is not just about domestic violence restraining orders. It is about something much bigger. It is about a legal test called the Brewin Test. And if you do not know what the Brewin Test is, you need to pay very close attention right now because this test is the engine running behind every single Second Amendment case in America today. Back in 2022, the Supreme Court ruled in a case called New York State Rifle and Pistol Association versus Brewin. That ruling was a massive win for gun owners. The court said that any gun law in America must be consistent with the history and tradition of firearm regulation in this country going back to the founding era. If the government cannot point to a similar law from the 1700s or 1800s, the modern law cannot stand. That is a very high bar, and it immediately put hundreds of gun laws across the country in legal jeopardy. But then came Rahim, and what Rahim did was refine and clarify the Brewin Test. The court said, you do not need an exact historical twin of a modern law. You just need what they called a historical analog. Basically, a close enough match from history. This matters enormously because it means courts have a little more flexibility when deciding whether a gun law passes constitutional muster. Some gun rights advocates saw this as a step back. Some gun control supporters saw it as a lifeline. The truth is, it sits somewhere in the middle, and the effects are still rippling through every federal courtroom in the country right now. If you are finding this helpful, wait until you see my next video. I am going to break down the 5 words you should never say to a police officer when they ask if you are armed during a traffic stop. Those 5 words could turn a legal carry into a criminal nightmare. Subscribe right now so you catch that video the moment it drops. Now, let us talk about what this ruling actually means for you on a personal level. Think about this scenario. Imagine you have a restraining order filed against you. Maybe it is a messy divorce situation. Maybe it is a neighbor dispute that escalated. Whatever the reason, a civil court issues that order. Under federal law and the Rahim ruling, you are now legally prohibited from possessing any firearm. Not just at home, not just when carrying any firearm anywhere, anytime. Here's what most people get wrong. They think a civil restraining order is not a big deal. They think it is just a piece of paper. But after Rahim, that piece of paper is now the thing standing between you and a federal felony charge. Possessing a firearm while under a qualifying domestic violence restraining order is a federal crime. We are not talking about a misdemeanor. We are talking about a charge that can land you in federal prison for up to 10 years. Now, let me be clear. Now, quick legal note. This is educational information, not legal advice. Every situation is different. Every state has different rules layered on top of federal law, and you should always consult with a qualified firearms attorney for your specific situation. What I am giving you here is a foundation so you're not walking into a courtroom completely blind. Here is the second thing the Rahim ruling did that nobody is talking about enough. It set a new standard for lower courts to follow when evaluating gun laws. Before Rahim, some courts were using the Brewin Test so strictly that they were striking down laws left and right because they could not find an exact match from 1791. After Rahim, courts now have breathing room to look at the principles behind historical laws, not just the exact letter of them. That means some laws that might have been struck down before Rahim now have a better chance of surviving a constitutional challenge. For gun owners, this means the legal landscape is more unpredictable right now than it has been in decades. A law that got struck down in your state 6 months ago might get upheld somewhere else today. That inconsistency is exactly what is driving a wave of new cases straight to the Supreme Court. Hey, real quick, 73% of people watching this video right now are not subscribed. That means almost 3 out of every 4 of you are at serious risk of missing critical updates like this one. Join the gun owners who stay ahead of the law. Hit that subscribe button right now. Be in the 27% who actually know what is going on. So, here is what is coming next, and this is the part that could affect you even more directly than Rahim. Right now, there are 2 major Second Amendment cases sitting before the Supreme Court in their 2025 to 2026 term, and both of them could reshape your rights before the summer is over. The first case is called United States versus Hamani. Here's the situation. There is a federal law that makes it a crime for any unlawful user of a controlled substance to possess a firearm. That includes marijuana. Yes. Even in states where marijuana is completely legal under state law, federal law still classifies it as a controlled substance. So, a person who uses marijuana in a legal state, pays their taxes, follows state rules, and keeps a firearm locked in their home could still be charged with a federal felony. Ali challenged this law. The 10th Circuit sided with him, and now the Supreme Court is deciding whether that federal gun ban for drug users is constitutional. Here's the jaw-dropping part. When the justices heard oral arguments in March 2026, they were openly skeptical of the government's position. Multiple justices from both sides of the political aisle pushed back hard on the idea that someone who uses marijuana recreationally should permanently lose their Second Amendment rights. That is a big signal. When justices across the political spectrum both start questioning a law during oral argument, the writing is often on the wall. A decision is expected by late June or early July 2026. If the court rules in Hemi's favor, millions of Americans who currently cannot legally own a gun because of marijuana use could see the restriction removed. That would be one of the biggest expansions of Second Amendment rights in years. The second case is Wolford versus Lopez. This one is about concealed carry on private property. Hawaii passed a law that says if you have a concealed carry permit, you still cannot bring your gun onto private property that is open to the public, like a store, a restaurant, a parking lot, unless the property owner has explicitly said guns are welcome. The default under Hawaii's law is no guns. You need a sign or a statement from the owner saying otherwise. Gun owners in Hawaii sued. They said this law effectively makes your carry permit useless because almost everywhere you go in public is private property. During oral arguments in January 2026, the Supreme Court justices appeared genuinely sympathetic to that argument. One justice pointed out that the whole point of a carry permit is to carry in public. And if private property owners can veto that right by default, the permit means almost nothing. This case has national implications. If the court rules that states cannot make no guns, the default on private property open to the public, it would gut similar laws in several other states. Your carry permit could suddenly be far more powerful than it is today. This information could literally change before the summer ends. Both the Hemi and Wolford decisions are expected before July 2026. Subscribe right now because my next video will break down exactly what those rulings mean for your carry permit, your rifle at home, and your rights at every location you visit daily. You do not want to be the last person to know. So, let us bring this all together. Here is what you need to walk away knowing today. First, the Supreme Court's near-unanimous Rahim ruling in 2 and 24 confirmed that your Second Amendment rights are not absolute. If a civil court finds you pose a credible threat to someone, you can be temporarily disarmed. That is now settled federal law. Second, the Brewin Test, the legal standard that requires gun laws to match historical tradition, is still the rule of the road, but Rahim gave courts more flexibility in how they apply it. Third, 2 enormous cases are heading toward decisions right now. One could give gun rights back to millions of marijuana users. The other could supercharge your concealed carry permit. This is not a slow news year for the Second Amendment. This is arguably the most active stretch of gun law history in your lifetime. Subscribe to this channel right now, not tomorrow, not after the next video. Right now, because when those decisions drop, you are going to want to be the person who already understands the context, not the one scrambling to catch up. I put in hours every week researching this stuff, so you do not have to. The least you can do is hit that button. Tap the bell too. Every time a major ruling hits, you will be the first to know. Finally, a quick but important disclaimer. Everything in this video is educational information only. It is not legal advice and should never replace a conversation with a licensed firearms attorney in your state. Gun laws vary significantly from state to state and situation to situation. Use this as a starting point, not a final answer. Stay legal, stay safe, and I will see you in the